please go ahead and flag that for us and let us know. To start off, I want to make sure that everyone has a copy of the draft that Professor Varelli so kindly put together for us. It is focused on the general provisions and then the qualifications section. So we're really focusing on the qualification section today. And our goal is to have a working draft that we're all have some sort of consensus about by the end of the meeting. So if you do not have that, please let us know. And thank you very much for getting that up on screen. Hopefully everybody can see that. So what we wanted to do, first I'm going to let Professor Varelli jump in and discuss, but just so everybody knows, we're literally just going to go through each of these provisions one by one and discuss any questions, anything anybody thinks we should consider as we're moving forward. I haven't met all of you. I'm Erin Worth. I'm in my day job, the Chief Administrative Law Judge at the Federal Maritime Commission. And I'm sure like anyone else who works for the government here, my comments are my own and do not reflect that of the agency. Professor Varelli, let me hand it over to you just to give a little general overview before we get started.
Great, thanks Erin, and thanks everybody for being here. So as many of you know from our original working group meeting, this is part one of several. We decided to do was to sort of break up the drafting into larger subsections. Today we're talking about what I'm calling qualifications. So who can qualify to act as representative? The next step will be how those representatives ought to act or what the guiding principles are for representative conduct. But here we've bit off a relatively modest chunk of the project, sort of get ourselves started. And because I think there are some distinct questions here that I didn't want to conflate with later questions about the nature of conduct. I also took the liberty of trying a couple of general provisions, sort of definitions and other things up front. It's up to Erin's discretion whether we want the subcommittee to focus on those today. I understand that we might not want to. Those are also works in progress, but I thought having some terms of art might be useful as we go through. In terms of things that keep me up at night, if what that's worth for the subcommittee, it is leaving something out. I am a failed engineer by training. I like to have all of the information in front of me first, and then to sort through it. And I thought very hard about keeping all of that information in front of me and all the different ways that qualifications might be discussed in the rules. But in addition to comments on what you see on the page, I'm also, and I know I speak for Erin too, I'm interested in things that aren't yet on the page that you all think would be useful. So without further ado, I will thank everybody again and turn it back over to Erin and be at your disposal.
You know, you bring up a good idea. The general provisions are going to apply to all of the subsections, I think. And it might be helpful just to jump into the qualifications, because I know that's why a lot of people are here. But I do want to keep these in mind, and perhaps if we have time at the end, we can go back. And if anybody has feedback, if we run out of time, or if for some reason you have to leave for something else, please go ahead and email us any comments or any concerns or anything that arises, you know, as soon as we close, that you think we should know about, because this is very much a work in progress. And the more information we hear, the more helpful it will be. So jumping into the qualifications, the first one is just a very general comment. Does anybody have any questions or concerns? So it starts Rule 200 in general. In accordance with applicable law, including these rules, a participant in an agency adjudication may be represented by a third party. Does anybody want to jump in either to this or has some kind of overview or anything that they would like to raise? Professor Varelli.
I just wanted a point of clarification I forgot about. Like any good law professor, I stole some of this from previous work. And when I have agency in brackets, that's meant to be the proper name of the agency adopting the rules. So agency, of course, is grammatically incorrect. It took me several draftings to overcome my instinct to make that an agency. I also took the format of the comment sections, the official comment sections from the model rules on adjudication. So those are all, as far as I'm concerned, those are certainly things we can talk about, but just so you know where I got my formatting from, that's also, as far as I'm concerned, something the committee should comment on.
Great. Hearing no other comments on draft rule 200, let's move to 201. Which is consent and requires that a participant must consent in writing to representation. I will go ahead and jump in with a question, which is, I know my agency and a lot of agencies are moving towards electronic signatures and electronic filings. Does anybody on the committee have a thought about the phrasing of consenting in writing? Professor?
I certainly don't want to be the dominant voice here, but I hadn't thought about that. That's a great point. I think maybe at a minimum, maybe putting something in a comment explaining that writing can include sort of electronic consent or acknowledgement. The idea here was to avoid purely sort of real-time oral consent for fear that maybe the participant would be not fully consenting in the presence of their presumed representative.
Jeremy, go ahead.
Sure. So lots of agencies also have standardized forms for providing this sort of consent. Would it be useful just to maybe as a, I don't know, A, B, or C here, almost put in a placeholder for the agency to provide agency-specific instructions for providing consent? In some cases, it might be that the party or the representative sends some sort of letter on letterhead. In other cases, it might be filling out an online form or submitting a paper form to an office.
Certainly, that makes a lot of sense. Ms. Rothschild?
Sure. How would you feel about in this section something like a notice of appearance? So like for our agency, we don't require written consent by a party to be represented by their lawyer. We do, however, often, very often, have the lawyers file with us a notice of appearance saying they're appearing on behalf of this particular party. And so I'm just wondering how you would feel about notice of appearance versus actual written consent for the representation.
Let's go ahead and get Ms. Olson's comment next.
I'm talking in terms of the Internal Revenue Service, and many times there are, you might have virtual hearings or in-person hearings, and they're not really hearings, but meetings, and the taxpayer will bring a representative at that time. And as long as the taxpayer and the representative are there together, then there's no question that the taxpayer's given consent. But to the more recent point, at some point, if the representative wants to receive, written information, et cetera, from the IRS, they're going to have them fill out. The taxpayer has to fill out a form authorizing the representation. But maybe we want some kind of recognition about, oral, presence at the same, at the time of a hearing where you're there and there's a recognition that the taxpayer's given it oral consent when you can actually see the taxpayer and the representative simultaneously.
Excellent comments and thoughts. Professor, do you want to jump in?
Sure, but I think we have another hand. I'm more inclined to get.
Yep. I just saw that come up.
Right.
Go ahead, Mr. Stock.
Thanks. I think I want to build on what Nina said. I agree that you get in a chicken and egg problem with agencies a lot of times, where if you haven't represented an individual before the agency previously, you're trying to find out just what's going on. The agency then says, well, you can't, appear before us until we have written consent. And it's like, great, well, I don't even know where to send written consent, because I don't know where the case is in front of your agency at a district office or whatever. So I think written consent maybe a little high bar for a lot of the kind of just sort of generic representation in front of an agency that's going to happen, in IRS and immigration, Social Security, et cetera. So just you're on the phone, you want to be able to be on the phone with the person who's affected by the adjudication, who can say, I don't know what's going on, but now I have a representative on the phone with me, and that person can now talk to the agency on the person's behalf.
Ms. Rothschild?
Yes, I do not have a good point to make, other than I want to say hi to Bill Stock because we went to law school together. Sorry.
Well, that's fair. And I also don't want to lose Ms. Robbins' comment, which is in, I think she sent comments ahead of time, who asked about whether it'd be better to identify the representative by name or affiliation, recognizing that at some agencies, there are entities that represent, thank you, that represent people. It looks like Social Security currently does not recognize the firm, but only the individual attorney. That's what I'm taking from that comment.
I'm happy to elaborate a little bit. Yeah, I did send comments
Okay,
ahead
good.
of time. Yeah, so I was just saying, I mean, modern business practices, at least, before, I guess, in different firms, depending on what agency you represent claimants in front of for Social Security, they currently do not recognize firms or entities as representatives, something that we currently are advocating for them to do. But anyway, my point was, I don't know if other agencies, if entities or organizations can represent claimants, but if they can, it might be better to say identify the representative by name or affiliation to kind of recognize that. So that was just kind of more of a question than a recommendation, but I don't know how it works in front of other agencies. Like I said, Social Security does not recognize entities, but they should. So that's kind of where that started.
Okay, that's helpful. Thank you. Ms. Olson?
Yeah, I think that, I don't have an objection to that as long as it's qualified by, to the extent the agency's statutes or rules allow, because with the Internal Revenue Service, you can only provide tax return or tax return information to an individual with the taxpayer's consent. And there's a whole emphasis on limiting that scope of to whom you are providing this very valuable personal and financial information. And I wouldn't want to see those privacy protections watered down, so that any random human being in an organization could get that information.
It seems to me there are a number of purposes of this consent, and it might be helpful to step back and think about those, right? So part of it is exactly what Ms. Olson said, to ensure that the private information, whether it's tax information or medical information, is only provided to someone who the individual consents to, right? So that's one purpose. There's also the second purpose of allowing the agency some sort of tracking mechanism of who is involved in a case. So as people talked about notices of appearance, so that agencies have some sort of record if somebody did show up at a hearing or on a telephone call of who that was, sort of for their record keeping purposes. And I think that may be a slightly different goal, and there may be others. So it might help us to think about the different types of reasons different agencies may be trying to collect this information. I think those were the two that jump out at me. And my guess is that, as somebody had said, most agencies are going to have some sort of rules somewhere else, right, that say how to do this, whether it's how to enter an appearance or what form is required if you want to represent someone. And so the earlier suggestion that we that this rule essentially circle back to whatever pre-existing forms there are might be a way that we could resolve that issue. So now, Professor Verrilli, I'll see what your thoughts are.
So, Aaron, I think that makes an awful lot of sense. I like the way you sort of broke it down, and I'm thinking now about sort of the words and how they reflect that idea. It might be as simple as saying, as getting rid of the phrase, excuse me, in writing, and say something to the effect of consent to representation either before or to the presiding adjudicator. Must provide consent to representation to the presiding adjudicator. And I'm of course open to any permutation of this. And then in part B, that consent must be included in the administrative note. A record of that consent must be maintained in the administrative record of the adjudication. I wonder if that leaves enough wiggle room for agencies then, of course, and a qualifier like in accordance with agency rules and applicable law, of course, is always fine. To Leah's point, I think when I was thinking a lot about your comment because I had a chance to think about it in advance, and I'm grateful for that. I think it might be that a cross-reference to 209, the accreditation of an organization, might be a way to talk about affiliation there, right? Because I think of a third, and I'm the least experienced in this in the group, but to Aaron's point about reasons this consent exists, the third one that I was thinking of is ensuring that that consent is informed and, sort of voluntary. And that's why I thought having something slightly more formal, like in writing, or at least in the presence of the adjudicator, was important. I also think affiliation then ought be qualified by an accredited organization, right? So an organization that the agency has already sort of signed off on as worthy of serving as a representative. And then by that rationale, I think affiliation makes perfect sense. I don't know if that's enough, if I've covered everything, but I don't know if addition by subtraction is really a thing, but I think that's what I was going for with some of the editing.
I have a question. If there's anybody in our group who regularly is involved in telephone hearings, how that sort of notice of appearance or entering an appearance is handled in phone hearings. Does anybody have any input or could help us with that piece?
I don't know how to raise my hand. I'm sorry. So
That's okay. Just jump in.
Yeah, at the Social Security Administration. So the notice of appearance or the appointment of representative form, whatever you want to call it, would be submitted beforehand, before the scheduling of the hearing. But if they do have some provisions right now that would allow the claimant to, I guess, basically say, this is my representative consent, and then on the record say, that kind of formalized representation, but then follow up with something in writing. I believe that's the provisions for Social Security right now. So,
any other thoughts on the phone hearing scenario? Then my other question was on this affiliation versus individuals. I believe my agency, individual attorneys put in their notice of appearance, similar to Social Security. Does anybody here work or have experience with an agency that does not require an individual, but only an entity to enter their appearance? Yeah, I think that may be a more unusual scenario, and I think there potentially could be complications in that.
yeah, I was going to say, I think that if the general consensus is it's all individuals, then my question has been answered. But I will say, it was intended to be recognized, the name of, I guess, at least in the Social Security context, you usually don't have just representatives who's just anybody kind of off the street. It's usually like a professional representative who's an attorney, or a professional non-attorney representative who is registered with the agency. And even as an individual, they can still be affiliated with a firm or an organization like legal services and stuff like that. So my, the points about giving, sensitive information, medical, tax, financial, all that, definitely well taken. But my point was not to say that you can just, identify an entity and then anybody in that entity can go and talk, but more to just, if that is a registered affiliated, a registered, I guess, firm or entity, than to just say the name of the affiliation or the firm instead of the name of the individual, because at least in law firms, it's not always the attorney calling the agency or submitting documentation to the agency for the case. It could be paralegals or case managers or things like that. So that was kind of the idea behind it, but I definitely I don't think it's worth it adding anything there if it's going to cause more concerns or problems. So,
Jeremy?
Well, we do also have official comments here. Would it be useful making some point to that effect in the comments, that some agencies might accredit organizations rather than having individual representatives, and perhaps that leaves some room and allows us to sort of explain what maybe some of the costs or benefits are without necessarily putting it into the rule itself.
And we have some great comments in the chat as well. Mr. Stock says that immigration agencies currently only recognize individual representatives. I think there may be some really practical reasons for that. And Ms. Olson suggests, which is great, how about in writing or in the presence of the adjudicator? And I think that makes sense, because I can certainly see situations where somebody shows up with someone. And so that may be a good way to handle that. Professor Verley, do you feel like you have enough here that you could revise the draft? I think we have a consensus on the general concept of what we would like it to say, if people are comfortable with it being an individual. Mr. Stock, go ahead.
Sorry, just two quick questions. One would be, do we here have any rule about withdrawal of consent? Do we think we need it? And then the second one would be, would there be any requirement to consent to any limitations that there might be on scope of representation? So for example, right now in immigration proceedings, all of the rules for non-attorney representation require it to be pro bono or for a nominal fee. So, would we suggest that any rule, consent to basically those limitations on representation?
And I was thinking about that as well. I know in the Social Security context, there are limitations on fees that can be charged and some specific information that in essentially their version of the notice of appearance is required. I think I'm thinking this may be why it's going to be helpful to refer back to whatever the agency's rules are about entering appearances, which I presume most places have some version of already. My other thought is that we do need to think about withdrawal of consent. I think that's actually very important. And we'll just circle that probably for a different rule, unless it needs to be in this rule.
I think that's a matter of taste. I think it could certainly go, because withdrawal of representation is slated for the next section. We're talking about representative conduct. And I don't remember if I conflated them or if I just overlooked withdrawal of consent, but I think it's an important point. I think it could fit here. And I would imagine we would describe sort of the mechanics of withdrawal, not the substantive criteria, right? There wouldn't be any real limitations on a participant withdrawing their consent, I wouldn't think, right? But I open that up as a non-rhetorical question to the group. Do we want to limit the ability of a participant to withdraw their consent once they've given it, or should it be freely retractable?
I know in some places the fee obviously can be an issue when, say you have a disgruntled claimant wanting to fire their attorney and there are rules about attorneys' fees that the agency enforces. Again, those agencies are going to have rules somewhere else that outline their requirements on fees, but that's what jumps to my mind as an issue. Obviously, there are some, well, there's some rules about attorneys, right, entering and exiting cases. What do other people think about whether the withdrawal should be included here in the consent section? I think
I
I'd,
think withdrawal of representation is a different issue to withdrawal of consent for representation. In other words, withdrawal of representation would be the representative saying for whatever reason I can't continue versus, and that should be its own rule. Withdrawal of consent would be, you know, I don't want my lawyer representing me anymore in front of the agency. That I feel like belongs here.
yeah, I think that makes sense. So I think in looking at our draft, C and D probably to some extent can be combined.
And just so I'm clear, the idea there is if the agency were to create or establish a standardized form, that would be adequate.
Right, some agencies may already have forms, so so in those cases, the agency would want to refer people to that form or the rule that explains how people enter appearances.
That actually goes to a larger point that I would like the subcommittee's wisdom on. So I found myself, as I was doing this, regularly saying, what happens if the agency already has a rule? And then I would find myself saying, am I writing this for the agency that doesn't? Right. So because I think the introduction to the rules will be agencies should feel free to adopt whatever sections they think are useful. Or we can qualify with consistent with existing rules and applicable law. There's lots of different ways to do it, but I found myself sort of wondering the meta question of who am I talking to? And I decided to act like I was talking to an agency that had never thought of any of this before. And I don't know if I succeeded in that, but that was the perspective. And that's something that I think is worth, I would like some clarification on to make sure that I'm doing it right.
And that would be very helpful to get the ACUS perspective, Jeremy.
Yeah, sure. I think the ACUS perspective from our work in this space is that agencies are all in very different places when it comes to these rules. And so this set of rules could probably provide a useful resource to agencies that fall along a spectrum of, I don't know, completeness of their actual rules in this topic. I mean, one way to maybe get at that is to actually either use the official comments to explain variation or to provide different options in the rules themselves, to the extent we don't think there's necessarily a one size fits all solution to everything. But I think it would be helpful if this resource were written in a way that it could be used for those who don't have such rules or those who are looking to amend or revise those rules, recognizing that one size probably doesn't fit all in this context. I also just wanted to mention on C, when I had mentioned a standardized form, not necessarily that we need a placeholder for a standardized form in particular, but something like you mentioned, Lou, going to the mechanics of how you actually submit consent. So for an agency, SSA has a specific form 1696 for providing consent. You would, I assume, want some reference to that specific form in these rules. So perhaps some subsection that just lays out whatever the specific mechanics are for providing consent, which is going to be very agency specific, of course.
Is that something that would be better in a comment or in the rule itself, do you think? Well, I have you on the hot seat.
I think you could probably do it either way. I mean, if you put it in the if you put it, I mean, I think if an agency is doing this, it should be in the rule, although I don't know that we could actually say much of the rule other than, you know, in brackets, agency inserts mechanics. I suppose you could have sort of an illustrative rule, you know, and say parties can provide consent in the following forms, list a few examples, use standardized form, you know, insert form number here, submitting a form through our electronic portal and lay out various options. And I think agencies will probably use common sense and figure out which ones are applicable or which other options they provide.
Ms. Rothschild.
I just wanted to provide our agency's answer to Professor Varelli's question in terms of, is this aimed at an agency that has no rules or someone that has some rules? I would just say that for all ACUS projects and recommendations, I've always approached them as, well, what parts of these are helpful to us? What parts aren't really applicable? What can we glean from this to improve our processes? And so I would say, you know, I approach it as these are best practices that are being recommended, and agencies who are often in very different places on these things will take from it what they will. That'd be my take on it.
All right, well, let's, because I don't want to spend all our time on this rule, but let's look, starting with just subpart A. Unless otherwise prohibited by law, our participant must consent to representation either before or to the presiding adjudicator. The consent must identify the representative by name and be submitted to the adjudicator or some other official designated by the agency for that purpose in advance of the adjudication. It sounds like we are agreeing to get rid of in advance of the adjudication to allow people to appear at hearings with a representative. Does anyone not agree with removing that phrase? Hearing none, strike it out. Any other suggestions for this subpart? Go ahead, Professor Varelli.
I would just suggest adding in writing or, either in writing or
Yeah.
maybe before or to now doesn't work as well with serial ors there, but consent to representation either in writing or before the presiding adjudicator. And then in the comments, include that writing, which I think we already have, that writing can include electronic consent or electronic acknowledgement.
I would think most agencies will want more than a name. I know a name doesn't really help our agency. They may want other contact information, but I think that's where C, referring them to the form and the information that each agency requires, is probably the most appropriate way to handle that issue. Any other thoughts on this as it is now written, section A? So I think it should be either in writing or to the presiding adjudicator. We need an or right there. Professor Vrelli? And you can just jump right in if you want.
I think if the group is comfortable with those things being sufficiently distinct, writing, in writing, or to the presiding adjudicator, that's fine. I think that's the idea. I think saying in person is too limiting in light of telephonic hearings, and this strikes me as finding the balance.
All right, if there are no other comments on A, B is a record of that consent must be included in the administrative record of the adjudication. Does anyone have any concerns about that? And then C, I think we may leave to Professor Verrilli to put what's going to be in the brackets. But essentially this idea of the agency inserting a link to whatever other rules or forms or information they provide. And then D, withdrawal of consent or limitation. Okay, so we need a sentence for withdrawal. Withdrawal of consent may be provided either in writing or to the presiding adjudicator. So that would just mimic the language in A and allow the same means for withdrawal. Does anyone think that the withdrawal process or description should be different? And I'm certainly open to any suggestions. I think the separate issue is limitations on scope of representation. I think that might be something that belongs in the comment that goes along with C, which is that if there are limitations, those should be noted. And again, I think that might differ from agency to agency. What do the subcommittee members think about putting that limitations language in the little note to the agencies in C? Do people feel like this is sufficient on this rule? Or do we need to come up with the language that's going to go in C? Jeremy?
Lou, in a future section, are we going to have something about scope of representation before the agency? I assume that might be a separate rule, in which case maybe it's just a cross-reference to that rule and have some indication here that if any sort of limited scope representation is permitted,
Yeah, there is a scope. In the representative conduct, there's a scope of representation rule noted in the plan.
So,
And it's modeled on 1.2 of the model rules of the ABA model rules.
so maybe it's enough just to say that, where limited scope representation is permitted with a cross-reference to that rule, some indication that the party is aware of and has consented to that limited scope representation. That might be sufficient.
Does that seem like a comment to you, Jeremy, or is that part of the rule?
I don't know how common limited scope representation is. I know it's obviously been an active issue in the immigration courts, but I don't know how common rules are elsewhere on limited scope representation.
Does anybody on the call work with limited representation in a non-immigration field? Okay. So it sounds like maybe that's something that can go in the comments, since it's a fairly narrow issue.
And a cross-reference to the later rule, I think, is a great idea.
Mhm.
I have two things, if our chair doesn't mind. The first is, I'm now coming back around on the in writing or two. I think maybe just two. Because one would submit the written, ostensibly one would submit the written consent to the presiding adjudicator. So I think consent to representation, I don't know if the verb is then, or I don't know what part of speech two is there, but must consent to representation, must provide consent to representation to the presiding adjudicator. Can you provide oral consent? I'm just thinking of I'm causing trouble now, and I'm happy to do it on my own. All these nice people have other things to do, I know, but if this is something the subcommittee cares about, I think to the presiding adjudicator would include in writing. And we could put in the comment that provision of consent can include oral or written consent, C, part C, form the mechanics. And then the same thing would happen in D. I would mirror the language of withdrawal. And in the withdrawal provision, I would mirror the language for consent. And then the last problem, Aaron, is fees. I don't know what we do or say about fees.
I think that should go in a comment, and it really is sort of in that. I'm wondering if C should really just be a comment that talks about the importance of referring to other rules, including limitations on representation, any rules regarding fees that may be applicable, or anything else we come across that might be important to add in here. Any thoughts on whether that would be better as a comment or in the rule itself? I mean, I think if an agency has those, they are just going to cite to the rules, right? They'll say C, rules X, Y, and Z. So I'm not sure the best way to provide that as a standard. But I think maybe putting it in the comment might be the easiest way, and then they'll read the comment. And if we wanted, we could bracket, see applicable or cite to applicable rules, and then in the official comment, discuss some of the type of rules that might be appropriate to cite to.
And that raises the same meta question that's been haunting me the entire time here, which is part of this project supposed to be to advise or give agencies some substantive guidance on how to handle fees, or just defer to their current whatever rules they may currently have? I don't know the answer to that, sincerely, but that's what that's the sort of thing I wonder about.
I would think even if it were, it wouldn't go in the consent section. So we could maybe table that for later to figure out if that would be appropriate somewhere else, but I don't think that it would go here.
I agree. That's really helpful.
All right. Do you think you have enough to work on consent? I know there might be a little wordsmithing, but in terms of the concept of what we were trying to say, does anybody have any concerns about how this is shaping up at this point? Then I'd like to move to the next three rules. I guess it's the next two rules, which are about licensed attorneys. So we have two rules specifically about licensed attorneys, and then 6 rules about non-attorney representatives. So let's look at the licensed attorney proposal to start with. And maybe I'll just give people a minute to read this as it's a little bit long, but also open to any comments if anybody wants to jump in. So I'll jump in and say this is requiring the filing of a certificate of good standing. I think that most agencies where I've worked don't require, like from your bar association, the certificate of good standing. They just require you essentially to assert that you are in good standing. From this language, I'm not entirely clear which is meant, or which it should be. If people have thoughts.
In terms of original intent, it just it meant effectively a declaration, not necessarily an official document from the bar, but it's an excellent point.
I think that's typically what we see, and having just gone through hiring, obtaining those certificates of good standing can take some time and delay people, which is the last thing we want to do, I think, is add expense or delay to the representative process. So
mean, I would just chime in to say there are federal courts that don't require you to get a certificate of good standing to get admitted to the bar. So I would definitely encourage deletion of that whole sentence.
Right. So and that's fine. And I agree it needs to be changed. There's no question about that. When I said certification, I just meant the representative certifying in writing under some sort of penalty, perhaps, that they are a member. So not providing a certificate. But I agree completely. That's not necessarily what this says. So I agree that's how we should do this. And excuse me, on as to how to word it.
Ms. Rothschild.
So I was just going to suggest that, yes, I agree with taking the highlighted sentence out, and then in the remaining sentence, change the word demonstrate to confirm or something like that, so that it's not saying you're having to prove it. You could confirm it in any number of ways, and hopefully by just, even if it was in your form for notice of appearance or something like that, it could say, and I confirm that I blah, blah, blah.
Yeah, I think that's a very good way to handle that. Confirm, represent, declare, state. I think there's a couple words we could use there, but I think that would essentially have the same intent.
Are we worried about having a record? In other words, could you do it orally? And if so, would it have to be on the record?
I would think that in those situations where it's a phone hearing or somebody is presenting the information to the adjudicator, that there would be some type of record of that event, but I don't hold very many telephone hearings. So if anyone is familiar with how that process usually works, would this statement cause any problems in that telephone hearing or virtual hearing context where somebody's showing up to represent someone?
Maybe it's as simple as saying must confirm on the record in the proceeding. And then put in the comments that could include a variety of things, including a written certification by the representative, an oral statement on the record, etc. And I do not have the on-the-ground experience with all of this, so I'm just spitballing. But my concern is that I think it's probably important to have a record of this if someone's relying on their bar status to serve as a representative. And maybe I'm wrong about that, and I again defer, but that was my instinct.
So I actually had a question, and again, maybe this is different at other agencies, but so I guess I'm not clear right now what this Rule 202 is supposed to be necessarily like referring to, because there's, at least in the Social Security Administration, there's the registration process for attorneys who represent Social Security claimants, and then there's the appointment process. So is this intended to be like almost like a registration to be a representative in general, or to just be an appointed representative in an individual case? Does that kind of make sense what I'm saying? So I can't imagine somebody like showing up with their, certificate of good standing the day of the hearing and saying, hey, I'm qualified to represent claimants, and I actually represent this individual person in their hearing. You see what I'm saying? So I think there is a difference between being eligible and qualified to represent somebody as an attorney before in these agency proceedings, and then also actually being appointed to a claimant's individual case, if that makes sense.
And I don't think this was aimed at the appointment piece in terms of, I know some courts have lists of agencies that can be appointed or whatever. My understanding was this was to identify essentially any limitations on licensed attorneys and whether or not they can represent people. So, so this is sort of the universe of people who can show up and represent someone. And if they're doing it under the attorney section, then they have to be in good standing somewhere.
Right. So I think that's kind of what I was thinking too. So I think it's maybe less of a requirement, in my opinion, to say that a licensed attorney would have to confirm on the record in an individual proceeding that they're a member in good standing. You know what I mean? Like that's something that's like kind of more to the appointment in an individual case versus actually being qualified and having to confirm to the agency or, you know, more generally that you're licensed in good standing, if that makes sense.
Jeremy.
Yeah, I think it's a great point. And agencies are obviously in very different places, specifically mass adjudication agencies versus, you know, smaller regulatory programs. Would it be helpful to say it must confirm in brackets, like to designated agency official? And then that way in the comments, you could actually explain, in some cases, there might be some sort of pre-registration process. In other cases, it might be on the record for a specific proceeding. That might be one way to handle the variation among agencies here.
And just as a practical perspective, you know, I don't think that people are necessarily, for example, I have nationwide jurisdiction saying I'm an attorney registered at, you know, this state necessarily. And normally 99% of the time it doesn't matter. When it matters is when there's a problem and it turns out they're actually not in good standing because they've done something bad and that's caused a problem, right? And so I think it is helpful somewhere in the rules that when somebody says, I am so-and-so from firm such and such representing this person, that they understand that they are representing, that they are a licensed attorney who has, is in good standing, and is eligible to represent people. And so I guess in my mind, just practically, that's where it's going to come up. So right now we have licensed attorney representatives must confirm to designated agency official on the record in the proceeding that they are a member in good standing of their licensing jurisdiction and are not otherwise prohibited by law from acting as a representative.
It would take out on the record in the proceeding if we're doing it this way. And that way in the comments, you would say that might be on the record in the proceeding to adjudicator, but it also might be as a general matter to, you know, Office of Representative Accreditation or something like that.
Okay.
I will just reiterate my gratitude to Alexandra for getting all of this.
Yes, Mr. Stock.
I don't know if we, so reading the comment about some of the sort of additional credentialing requirements that might be recovered by some agencies, I think as a private bar member, I sort of feel like a stronger statement that licensed attorneys are presumed to be able to serve as representatives just because they are members of the bar before the agency would be one comment. I don't know if that's making A little bit stronger. And C would, do we add a C where we say, agencies are encouraged, advised, or whatever, that they can, collect or create records of, lawyers who are authorized or have previously represented in front of them, right? So agencies may have various, mechanisms of docket controls, et cetera, and that sort of creates a de facto bar because either you have signed up to be part of that electronic system or you haven't. But that may make things easier for the agency when we get to then the discipline step to be able to say, well, we've got a list of people who we one time vet that they were in good standing or whatever, and then we maintain our list. If the agency disciplines you, they kick you off that list. I don't know what people think about that, but
that is, I think, a related and different, but absolutely worthy concept to discuss, which is it helpful for agencies to maintain these lists? And I would imagine that answer is yes. Is there anybody who has concerns about agencies maintaining lists of qualified representatives?
I certainly don't. I just wonder if we then presume that there's an implied confirmation of good standing every time that person appears. So to Mr. Stock's point, the Agency Practice Act absolutely permits them to do it. So what I meant to say is you can be a representative, period. And part B was a suggestion that it would be nice to have it on the record, have a record of that good standing, even if it's just the representative asserting that they are, giving their word that they are in good standing. So really, this is sort of a fait accompli, this rule, and that by law, they're allowed to do this. The only real value added, if any, is the putting it on the record that they are, in fact, currently in good standing. And I wonder how a list, again, I'm not suggesting it's not a good idea, but a list of people who have appeared before still begs the question, are you still in good standing?
In my experience, I think it is helpful to have in each agency's rules or practices the fact that an attorney may represent them, because agencies tend not to look beyond their organic statutes, and referring them back to the Agency Practice Act gets you into, well, but how do I know that that applies to me and whatever. So that is sort of why I think it's helpful to have as a just blanket statement, like we all assume, and in accordance with the Agency Practice Act, that the default is that a licensed attorney should be considered eligible to represent. And these other rules are to expand that, not to say that licensed attorneys have to go through some supplemental registration training, et cetera.
Right.
Ms. Olson.
So, I can only speak to the Internal Revenue Service, but it has its own Office of Professional Conduct, Professional Responsibility, which is charged with overseeing and implementing the regulations under Title 31, Section 230, which regulates practice before the Internal Revenue Service. And people who will represent taxpayers, including in a hearing, have to get a CAF, a specific number that's maintained on the IRS's system. And when they submit an authorization to represent, which would be a power of attorney, essentially, that's the name of the form, they have to put their CAF number on. And there are, when you get your CAF number, you tell what your designation is. Are you an attorney, et cetera? That file is very helpful because it's a centralized file. So if someone complains to the Office of Professional Responsibility, and after investigation, that person is, that representative is struck, then you have a centralized system to make sure that other people who have granted powers of attorneys to that representative are notified that that representative can no longer represent before the IRS in matters, whether it's for suspension or for a period of time. And it's also a way to, well, I'll just leave it there. So I think we don't want to limit what agencies have already created. And I think there is a practical effect for keeping such a centralized, record system.
That sounds like an absolutely wonderful system. Are the people listed on that available? In other words, if somebody is looking for a representative, can they access that list somehow?
That's actually really good. No, I don't think so. I think what there is a separate list for persons who are preparing returns, and that list can be searchable. But the list of representatives would not, because also this goes to another section where you would be a non-attorney representative, where you have certified public accountants or enrolled agents, persons who've taken an exam before the IRS, in order to represent, and even family members or others can represent, represent in the capital R word, speak to the IRS on behalf of that taxpayer. But they would all have different designations on that system. An attorney is one such designation. And it's sort of what you're saying is that you say that you are in good standing with the bar, and you have to, I believe you list your bar, you list your bar jurisdiction. So that if the IRS wanted to check it, they could go and verify that you're a member of good standing in the state bar licensure records.
And I wonder if that's a good way to resolve the issue we were talking about in terms of rather than identifying or certifying that they're a member in good standing, is it really just a matter of providing information regarding where they are a licensed attorney? And would that sort of fulfill what we're looking for in this subsection B? Or maybe we just add it as a supplement.
For what it's worth, the IRS form says, I just Googled it right now. I am one of the following: a attorney, a member in good standing of the bar of the highest court of the jurisdiction shown below, which would be, your state. And then CPA says a holder of an active license to practice. I guess they don't have to be in good standing, but you have an active license. But, officer, a bona fide officer of the taxpayer organization, etc. There's just lots of choices, but they do say for attorney, member in good standing.
Yeah, and that's the language we have as well. So that's actually very good. Licensed attorney representatives must confirm to the designated agency official that they are a member in good standing of their licensing jurisdiction and are not otherwise prohibited by law from acting as a representative. That may be sufficient to cover this issue. I think this C that we were putting in, agencies are encouraged to create records regarding representatives who are authorized to practice in front of them, probably does not belong here because it would potentially include both attorneys and non-attorney representatives. So we may need to stick a pin in that and figure out where it's going to go. But it would apply, I would think, equally to both. Okay. Anything else on this section, 202? I do want to move us along. I appreciate everybody's input, I think, especially for these early ones going through and talking out some of these issues is really helpful. So anything else on 202? All right, let's move to 203. So this is the second attorney provision, which is waiver of good standing requirement for licensed attorneys. If they're not a member of good standing, they may not serve as a representative in an adjudication without prior written approval of the presiding adjudicator. Approval shall only be granted when the adjudicator determines that the representative has the necessary character and fitness to serve in that capacity, and the adjudicator may condition that approval on the attorney representative completing CLE or other relevant training. Any thoughts or input on this section? Go ahead, Mr. Stock.
I feel like this is I would propose deleting this, right? If an attorney is licensed by their bar, that should be sufficient. If they're not licensed for their bar, they certainly shouldn't be representing people before agencies, because that would normally be outside the scope of what a disbarred or suspended attorney would be able to do legally, as far as I'm aware.
Ms. Rothschild.
I agree with Mr. Stock. I was simply going to say, I don't even know how an adjudicator would do B or C. It basically either somebody is representing themselves as an attorney and they're licensed, they're in good standing, or they are trying to represent someone not as an attorney. And for our agency, that would be fine because we don't require the representatives to be attorneys. But I can't imagine one of our adjudicators wanting to send people off to do CLE or trying to somehow gauge their character and fitness.
Does anybody object to deleting this section 203? And I agree to some extent, this may be covered by the non-attorney representative section if they could so qualify under that, but they would not be qualifying as an attorney.
I do not object. That's what the subcommittee prefers. My question would be, are there situations where one could lose one's good standing status and not have that reflect on their fitness? For example, if I just stop paying my dues without taking the time to go inactive.
I would say as an adjudicator, I would not want to make that call. I'm trained to make calls on maritime issues, not on character and fitness issues. And that's just not sort of within my area of expertise. And that may just be me.
And I certainly don't blame you, but we're going to ask them to do that, to ask you all to do that in two or three rules though, or with non-lawyers. The reason this is in here is because I didn't think that a lawyer not in a formerly licensed attorney not in good standing is a non-lawyer. Right, so I don't think the other rules scoop these people, this group of people up. Because I just don't think it does. We could certainly do it that way. And it might be that this slice of the world, per Mr. Stock's point, just doesn't qualify, and that's fine too. But I was thinking of a category of people. Well, there's other agency rules about this. But go ahead.
Sorry, I'm happy to take as a to-do to sort of ping some of the professional responsibility folks who I'm familiar with, just to make sure. It just strikes me, as Ms. Rothschild said, that this is, even if I'm administratively suspended, I'm suspended. You know, it's sort of like going to the driver's license folks and saying, well, you know, my license wasn't suspended, but I'd like to get it back. But I was driving the whole time. You know, that doesn't put you in a great place with the adjudicating agency. So similarly, if you said, hey, I was representing agencies, I don't think bar associations would appreciate it if the federal agencies were backdooring a legal practice ability onto their suspended attorneys.
Absolutely. I'm just wondering if there's a more benign situation in which you could qualify under this rule, right? So if I'm a retired attorney who is I'm not a member in good standing if I'm no longer a member of the bar, right? I'm not a member at all. That's what I'm not advocating for the rule. Deletion is perfectly fine by me, but I'm thinking of the retired attorney who has all the skills set one would want, but simply isn't a member of the bar anymore, but is also not a non-lawyer. Unless we define non-lawyer to be someone who was a member in good standing and no longer isn't. Or I don't know how to do that, right? I guess it's just a matter of the terminology needing to be adjusted. I'm sure it can be done.
Ms. Rothschild?
I was just going to say that's a good idea. Let's just deal with it in the definition of non-lawyer, because I think they would fall under non-lawyer.
Well, if everybody agrees with that, that's wonderful, because it brings us to our next rule, 204, representation by non-lawyers. A non-lawyer may serve as a representative in an agency adjudication if the represented participant consents on the record to the representation and the representative is determined by the agency to have the necessary character and fitness to serve in that role. My first question is this consent different than the consent we talked about in Rule 201? Because if it's the same thing, I would think maybe that piece of it could come out.
I do not think that it was, I did not intend for it to be different.
Okay.
What I did probably was add that standalone consent rule after I wrote this one.
So for the attorneys, we don't have the consent a second time. So I would recommend taking it out here. So then the question is, does the representative need to be determined by the agency to have the necessary character and fitness to serve in that role? Does anyone have any concerns about agencies determining character and fitness for non-lawyer representatives. Ms. Rothschild.
Yes, I think that we would not want to go down that path. I think that if the person wants to be represented by this other person who doesn't happen to be a lawyer, then that's their choice.
And it is interesting, we didn't go through the definitional piece, which is up in section 100, but I know for myself, one of the things I had flagged was the definition of representative, which we had as our working definition, but we might need to change. As an individual appearing in an adjudication on behalf of a participant, representative may be a private licensed attorney or non-lawyer, but may not be a government lawyer or current government employee. That gave me the impression that these rules were not designed for family members, which is, I think, a large category of people who appear at hearings and speak and assist other people, but maybe are not what we intend by the term a representative. Have I confused people?
I think, let's put it this way, representative is meant to include family member.
Okay.
And by either being an attorney or non-lawyer. That government lawyer and employee language comes from the ACUS recommendation. And I wasn't part of that process, but I gathered that pretty clearly from the recommendation. But again, if we need to wordsmith that to include it, that's certainly fine. But absolutely, I meant for family members. The tricky part about character and fitness is protecting the represented party, or the represented party, right? I mean, if they're being lied to by a non-lawyer and for example, I'm not allowed to choose my representative in court, even though I may want to, and I do not envy the folks behind the bench in this situation, of course. But I just sort of wonder how we balance that. Can we protect the participant adequately with these rules without making that judgment?
Ms. Robbins? Oh, you're on mute. There you go.
I figured out how to raise my hand and then I couldn't unmute myself. Okay, I'm having a lot of problems. Sorry. So I was just gonna say, I agree that protecting the claimant should be key. And non-lawyers, especially when there's fees involved, right? So I think that, I don't know if it's character and fitness or some specific qualifications, but I think you do need to have some standards for non-attorneys representing claimants. But my understanding, and maybe it's helpful to use the term like professional representative when we're talking about who these rules would cover, because I think there are plenty of times when you can have a family member assisting you or even really appointed to be a representative, right? So, but they're not professional representatives. They don't do this for a living. They're not getting a fee from your case or anything like that. They're really just there to help and aid you in your case. Whereas a professional representative could be a lawyer or a non-lawyer, but it's somebody who really does this, they do this for a living, right? They're going to charge you a fee. And I think my understanding, at least, was those are the type of representatives that we want these rules to cover. But I don't know if it should be expanded to family members and all that. But I think in terms of protecting a claimant, I think it's less likely that, they're going to be, maybe not, right? I guess it depends on the situation, but that they would be, taken advantage of, hopefully, by a family, a family member or a friend that's really not charging them a fee for their services and things like that. So I don't know if that's a helpful distinction, but just throwing it out there.
And that's the same distinction I had, is the sort of professional representative who is doing this as a business, as opposed to somebody shows up and their child is translating or helping them. I mean, that person the family member is going to be held to it, I would think, to a different standard than a professional who is being paid a fee to represent someone. So I like the addition of the professional representative. I'm still not entirely sure how agencies will assess the character and fitness. I've tend to seen it done in the opposite, where there's a problem and that's withdrawn. Mr. Sandman?
Yeah, I think this is risky territory for administrative agencies to enter. If you analogize to the bar admission context, character and fitness determinations are complicated. They require the submission of a lot of information, often lengthy employment histories. How is an administrative agency going to do that and do it consistently without setting up an apparatus mimicking what it is that the bar does when lawyers are applying for admission? I think there are other ways to protect consumers. There are consumer protection statutes of general applicability. There's the law of negligence, the law of misrepresentation. But we're looking at depriving people of their choice here, their choice of representative, by suggesting that the administrative agency is going to make its own determination of the character and fitness of the person to represent the individual. Moving ahead a little bit to the next section, I question the scope of the apparent meaning of the term fitness. In the bar admission context, I've always assumed character and fitness to be considered roughly synonyms of one another. But when you look at the requirements, what the administrative agency looks at here in determining fitness, they're going well beyond what a bar admission authority would typically consider to be within the scope of character and fitness. And I think it gives enormous discretion to the administrative agency to determine, say, that someone who's not a lawyer isn't fit.
Thank you. Very helpful comment. Mr. Stock? Oh, we lost
One
you.
of the suggestions might be that we do carve out some of the things that people have identified from what is a representative, so that a family member, assisting might not be, or so I mean, the things that jump to my mind. Someone said translator, but I think it's critical that we identify a translator who is doing nothing more than translation, right? So the translator who crosses the line to advocacy is now our representative. The power of attorney, right? So whether that's in loco parentis or whether that's because of an incapacitated respondent, the power of the person with power of attorney is the person, not is the representative. And so would be outside the scope of these rules. But I disagree with Mr. Salmon, and I think it is incumbent on agencies who are going to allow non-attorney representation to then create an infrastructure for how non-lawyers are accredited. So the immigration agency model, for example, is that they will accredit organizations which have to provide an infrastructure, supervision, and training, and then voluntary agency representatives under those organizations. So that's, and I know that model's laid out in later rules. So I would encourage that yes, there is a role. If you're going to hold yourself, if you're the adjudicating agency and you're going to say we will accept representation by anybody, I'm a little leery of buyer beware. When a person is going to be able to go out into the marketplace and say, well, I have been recognized as a representative by the United States Department of yada, 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 that really in immigration, we have this problem all the time where people use the fact that they're designated as a notary. And in Spanish, notario means attorney. So people say, well, I'm a notary public, right? Which then everyone in the community assumes means I'm an attorney, but of course they're not. So yeah.
And maybe it might help to scroll to the next Rule 205, because this is describing the character and fitness qualifications that I think Mr. Sandman was concerned about. The next Rule 206 discusses professional licenses, and I think that may be a somewhat easier one in that there are a lot of agencies that specifically do, as Mr. Stock was discussing, have specific professional licenses which then qualify the person. Mr. Sandman, you had your hand up again, I believe. Oh, you're on mute.
Sorry, I didn't lower it.
That's all right. Professor Verley?
Thanks. So I agree with Mr. Stock, but I also agree with Mr. Salmon, certainly in this regard. I think character and fitness might be the problematic phrase, right? To the extent that it evokes bar membership. Because if I think comment 2 of 204 was really the idea, sort of not willing or able to act in the best interests of the participant. And the list on 205 may be too dramatic or too formal. But I think A1 is the representative's relationship to the represented participant, right? So I think the idea is a wide range of people, and I'm not suggesting the rules capture this, right? But I think for what it's worth, the idea is to put the agency in the position to say, at a reasonably low bar, this person acting as a representative is willing and able to do what's in the interest of the participant, because otherwise the role of the representative is entirely backward or unhelpful. And I envision that being a pretty low bar. That list on 205 is meant to be inclusive, but certainly not a series of elements, because you would get to way overqualified people really quickly. But just just by way of explanation, I think comment 2 on 204, in light of what I'm hearing, might be the best way to characterize what's.
Ms. Rothschild?
I was going to suggest that if the term character and fitness is giving us heartburn, that maybe instead of using that phrase, we say qualifications or qualification standards, something along those lines. And then I actually had one comment about the 204. I'm not sure if anyone
Go ahead. Yeah, go ahead.
mentioned where it says that in the first sentence, it says a non-lawyer may serve as a representative in an agency adjudication if the represented participant consents on the record. I didn't know if we talked about changing that, but I was just going to say, if we're going to say on the record, could we also say in writing or on the record?
Yeah, I think let's just take out that section. I believe it duplicates the consent from above.
Right, and comment 1 says we're talking about 201.
Okay.
Right. So yeah. So I think that's an excellent comment, and I agree with that.
Somebody was trying to talk, but we didn't quite catch you.
I'm sorry. Do we want to remove this rule entirely? Is that what I just heard, or no? Just take out.
From in the first line, if to the and, just the and right where you were. I think that's the part we're deleting.
Great. Thank you so much for the
and delete the
clarification. And delete the and. All right. Very good. Sorry about that.
So now it's just a non-lawyer may serve as a representative in an agency adjudication if, we still need the if the professional representative is determined by the agency to have
the necessary qualifications.
Yeah, the necessary qualifications to serve in that role. Does anybody have concerns about that language? We would delete comment 1 from the official comments. All right, so no concerns about 204 as we have it now.
I think we do have a hand.
Oh, sorry, Ms. Rothschild. Thank you.
Forgot to lower it, sorry.
All right. All right, so if that's 204, we agree that there may be qualifications. The change to 205, instead of character and fitness in the title, it would be qualification standards.
And I'm sorry, but the risk of drawing the group's ire, I'm stuck on the word professional in 204 now, right? Do we really, are we really only talking about people for hire in 204?
Go ahead.
Again, I
Yeah,
think
go ahead.
I see the comment has already been added to sort of add a comment which contains the exceptions for translators and parents and such.
And Ms. Rothschild, go ahead.
Yeah, and I was just going to say, thank you, Professor Varelli, for reminding us about the term professional. I understand why we added that word, but I'm not sure it's necessary because the representatives could be non-professional. As we've talked about, as long as they're qualified and they are able to do a good job, it should be fine. I'm with the National Labor Relations Board, and in our circumstances, especially early on in cases, they may not be attorneys who are representing the charging parties. It might be a union rep. It might be, you know, a business agent for a union, and they're not being paid by the person. I don't know if they qualify as professional, but they certainly are recognized as representatives for people in our processes.
Yeah, so let's go ahead and take that out. I think that was useful as we were thinking about the different roles, but may not belong in the rule. So if we can turn now to 205, can always jump back if we need to. Qualification standards for non-lawyer representatives. And this is my understanding, not necessarily complete rule, but a sample of the types of considerations agencies might give. It sounds like there's at least one person who may be in favor of not having this at all, and people who are in favor of it. Do we want to have any more of a discussion about whether we want to have these qualification standards? Okay. Well, my inclination would be to leave them in at this point. And you know, we're the small subcommittee, we may get more input later, but it would be easier to take out the rule than to add it in later if we decided we wanted it. In terms of the qualifications that are listed, are there any that should be deleted or qualifications that should be added? Ms. Rothschild?
This is just a form comment on sub A. It says the necessary character and fitness to serve. I would just say the necessary qualifications to serve. And is anyone troubled by number 2, which is communication skills?
That seems very different from knowledge of the relevant subject matter, and also very difficult to, communication skills are difficult to figure out. For example, I would think as an adjudicator, but knowledge of the relevant subject matter would be much easier. So perhaps we could delete the communication skills. So the relationship, knowledge of the relevant subject matter, experience, education, training, skills related to the adjudication, character and professionalism, previous charges or convictions of a crime, whether there's been previous disobeying of agency rules or directions. Any concerns about any of those, Ms. Rothschild? Okay.
I would just add that the that list mostly came from the DOL's rule, but I have no objection to taking out. I appreciate the communication skills language is problematic in potentially several dimensions. And apparently I was being paid by the number of times I used the word relevant. So I think relevant can come out of numbers 3, 4, and 5, because I think versions of relevant also appear later in that clause. So the representative's experience, the representative's education, the representative's expertise or skills, I think will all work just fine. And I will forego whatever fee I accrued by overusing that term.
All right, moving on to B, a non-lawyer's representative will be presumed to lack the necessary character and fitness if prohibited by law, or if previously disqualified or suspended from acting in a representative in the same or similar proceeding within the agency. Any thoughts on or any concerns about that language? Ms. Rothschild, go ahead.
Just for consistency, I would start it out by saying in B, will be presumed to lack the necessary qualifications to serve.
Right. All right. Are we ready to move on to 206? Non-lawyer representatives with professional licenses. Non-lawyers who retain other professional retain other professional licenses relevant to the subject matter should be presumed to have the requisite qualifications instead of character and fitness to serve. And the presumption depends on the representative being a member in good standing of the professional licensing organization at the time of the representation. I think that's the same language we use for lawyers. Non-lawyer representatives may demonstrate that they are a member of good standing by filing a certification of good standing with the presiding adjudicator. I think in the lawyer context, we essentially took this sentence out. I presume we would want to do the same in this section, unless somebody disagrees. So everybody's just getting tired, so we're just becoming very agreeable, but I appreciate everybody's patience in going through this. I know it gets into the weeds, but it's really helpful and important. Any other thoughts about 206?
Alexandra, are you able to bring that language forward from the first use of it to the second?
From the first use
So
of,
in 206, we want to mirror the member in good standing language, or get rid of it in the same way we got rid of it in the
but I'll put in a comment bubble and I'll fix that after the fact. So
Great.
you all aren't seeing me copying and pasting on the fly.
Yeah, I
Is that-
really
is that-
just meant
does
to
that
say
work
that
for
I'm
you?
not doing it, so I'm grateful for that. Thank you.
Happy to help.
Thank you.
Is there a difference between professional licenses and occupational certifications and licenses? I don't know the answer to that. Does anyone have any thoughts on that?
Maybe that could be something in the comment to define professional license more broadly.
Yeah, I think
I don't know of a difference. I wasn't thinking of a difference.
yeah, that was a comment in the chat and very helpful. But I think you're
Yeah, I'm sorry. I
No, it's fine.
wanted to raise it just because every state seems to use different language, and that may be an accidental constraint by using just professional. I also wondered if medical license might be limited to doctors instead of inclusive of nurse practitioners and physician assistants and other tiers of healthcare providers.
That's interesting. Does anybody know if Social Security limits representatives to doctors, or if they're open to other medical professionals? I'm not sure, and I suspect there would be people interested in being representatives who were not doctors. And that may be something we want to leave open, at least for the agency to consider. Do you think that expanding the definition of a professional license in the official comment is sufficient? In other words, adding something that's saying professional licenses may include, I'm not sure exactly the language we would use to expand that. But I agree that each state calls things different things. or maybe broadly construed.
To
I think-
include any sort of recognized accreditation system within a jurisdiction? Something extremely generic?
Mhm.
And I wonder if agencies can, I mean, obviously agencies could put in their own limitations if that's something we should suggest. For example, if an agency wanted to limit to, say, doctors, but not other medical professionals, or some level of nurse practitioner, but not a regular, however they wanted to distinguish. I assume this is where they would do that, but I think also in terms of providing a sufficient number of affordable representatives, we may not want to suggest limiting that, right? The more broad that definition is, the more options claimants would have.
I would just vote for a more expansive language that will include all of those categories. I think professional is probably too limiting.
So in the rule, non-lawyers who retain other licenses relevant to the subject matter of the adjudication should be presumed to have the requisite qualifications to serve. Any concerns about that language? And I would say the presumption of instead of fitness qualification for a licensed non-lawyer representative in subsection A depends on the representative being a member of good standing of the professional licensing organization at the time of the representation. I think the professional is okay in that scenario because we don't want them to make up a licensing organization. Yes, Professor Verley?
So first, I agree completely with Ms. Last that we want to be inclusive here, but I'm wondering if we define professional license broadly enough, if it just sort of starts to look redundant with 205. In other words, I would think somebody with a relevant certification or any sort of credential would relatively easily overcome the criteria in 205. This struck me as more of a presumption, making it easier on the agency to just say, if you are a board licensed physician, if you are a board licensed engineer, if you are right, that you are, if you're a CPA, that you are presumed qualified the way that a JD would be, as opposed to sort of acknowledging, and rightfully, because I think they would be meaningful, but sort of creating the same sort of presumption for every certification that might suggest a qualifications to serve. Did I make any sense? Am I getting tired too?
No, you did. And I think, I think it's helpful to have this rule, which is somewhat more narrow than the rule before it, right? Which is a little bit broader in terms of anyone who has the right, essentially character and fitness, although we've changed those rules. Because I think there are some agencies who will not adopt the rule before this and will adopt this. I think that this rule in particular applies and is consistent with how a number of agencies operate, whether it's CPAs or engineers, as you said. So I think that having the comment about broadly construing it is fine and doesn't undermine the value of having this specific rule for people with professional licenses.
So does that counsel putting the word professional back in A? That's really what I'm thinking about. I'm comfortable construing it broadly because I do think ultimately the agency can decide for itself whether a particular credential gains this presumption. But I'm wondering if the adjective professional does some useful work here compared to Rule 20 when distinguishing this from 205.
I definitely like professional personally in the professional licensing organization. I think the question is, what does a professional license versus a non-professional license mean? And I'm not sure.
I think it just, the language varies so much, and there's occupational, there's vocational, there's certification. So I appreciate the need to wanting to give authority to some entity that is doing that screening, but I think professional means something different from the other categories, and even that will vary state to state.
And I guess my example to follow on with that would be maybe somebody who's doing work for the VA or in front of the DoD, that they may be licensed by some sort of organization that accredits people to represent in those types of cases, but it might not be a professional license in the way we were talking about a doctor or an engineer that a layperson would necessarily think of. But yet they still have specialized training that is appropriate. Does that make sense? Does that help?
It does. I think that maybe we should take professional out of the title too then, which is also fine. But
Yes, I agree. Excellent. All right, I know we've got about 15 more minutes, and I do want to move forward. If we can, 207 is law students and law graduates as representatives. So this applies to current law students and law graduates who are not yet licensed, allowing them to serve as non-lawyer representatives, provided they act under the supervision of a licensed attorney or faculty member and do not receive remuneration for their services. Any thoughts on this section? I have a question, which is, and I don't know the answer. Can provider organizations be paid? In other words, if they're working, the law firm, I assume, can be paid even if that individual is not. I'm not quite sure how that works. But I'll hand it over to Ms. Lash for her comments.
Yeah, I think I was following on your thinking. That students will be hired by a nonprofit or by a firm or some other entity, and they're getting paid. So I'm wondering about the limitation, why it was put in that they can't receive remuneration for their services. Is there a reason?
that is sort of the model that's out there. So agencies that have adopted this model have precluded law students and law grads who are unlicensed from being paid for acting as representatives. That's just descriptive, right? That's not meant to be persuasive.
Mm-hmm.
And I understand that if it's, part of the law school curriculum, sort of, the students who are doing their practicum. But I think there is this other category potentially of legal services corporations or someone that is utilizing these people and that may be compensated. Does anyone have any thoughts on that? Ms. Lash, your hand is still up, but I think it might just be continuing. Well, if that's this, whoop, you're muted. There you go.
The question has been discussed at length in the clinical law faculty community about whether or not students can get paid when they're getting credit. And the last I'd heard, it was allowed. But I've been out of that world for several years, so that could be wrong. But if it is the norm now, then that would be contrary to the other model that would preclude payment. It may be worth investigating. I'm happy to do that.
And I can follow up on that too. I supervise a few externships here, and we do not permit it, but I am not expert enough in the clinical world to know what the best practices are more broadly, but I have a colleague who will know. So
Mhm.
if that's something we'd like to know, I'm certainly happy to follow up with her.
I think it is, and I know that in the federal hiring, it used to be, at least in my agency, all interns were unpaid until they realized that was creating a real equity issue in terms of gaining experience during law school. And now there's a move to have more paid internships.
Mhm.
So that may be a concept that is evolving.
But paid versus paid while receiving credit is really the issue. Can you double dip, so to speak?
Well,
But this doesn't say that
This
they're
doesn't,
getting
no.
credit, right? So
That's totally
somebody
right.
could be getting neither. And I also don't want to set up a thing where new law students are receiving neither pay nor credit for their
Agreed.
work, Mr. Stock.
Agreed.
yeah, the language I'm familiar with is that they are appearing without direct or indirect remuneration from the person who is the subject. That I think does allow for you to be paid for, so you could be receiving general pay from the law school, for example, to participate in the internship, or even from the nonprofit, as long as the nonprofit is then not recovering a fee from the person being represented. So I think, look, I would encourage I don't know if we're sort of doing encouraging language in the comments, but I would say we should make a stronger statement that we encourage agencies to allow law graduates and law students to appear in front of them under the supervision of licensed attorney, faculty member, or accredited representatives, right? Because you could certainly have a situation where a law student is appearing, under the supervision of an accredited representative who is not a lawyer, but who is themselves, allowed to appear before the agency. But I also very strongly feel that you want to decouple the financial aspects of that, right? So if the clinic is getting paid, the law student shouldn't be. If the person is receiving those services pro bono, then it's okay for the law student to be providing them for pay as a general pay. But I'm one vote, so.
How would you change that 207A2? Do you think that
our appearing without direct or indirect remuneration? So essentially, the respondent can't, the person in the agency proceeding can't directly compensate the law graduate, and also can't compensate someone who then compensates. So sort of washing the fee through a supervising agency, and maybe then a comment on the remuneration rule to just say, direct or indirect remuneration would not include a stipend provided for participation in the internship that is not funded by, legal, fees from the beneficiaries of the services or something like that.
Ms. Rothschild?
Just to go back to 2, I agree with Bill Stock's suggestion. I would just add the language just a little bit. So it says are appearing without direct or indirect remuneration, but then after remuneration say for their services from the party to the proceeding or the party they are representing or something like that. Party they are representing or I think that would be clearer.
Excellent suggestions, everyone. Good teamwork on this. Thank you all. All right, any other thoughts on the law students or law graduates?
I think we need to clean up the B to reflect the decisions we've made earlier about statement certifications or confirmations of status. And so maybe that works for everyone, but I want to make sure that we're comfortable with that.
So we have scheduled this to go until 3 o'clock. And we have 3 rules left: accreditation of non-lawyer representatives, accreditation of organizations, and requirements for organizational accreditation. Does anybody have a proposal on if this is a good time to stop? If we want to try to get some thoughts down? I know that people have commitments after 3. I know we had hoped to not have another meeting. We may need to have another meeting, or we can try to exchange thoughts by email. I'd like to hear people's preferences on the subcommittee before we make any decisions. Professor?
Maybe with the most vested interest in. I would be very grateful for another hour or so of this group's time, maybe incorporating everything we've done thus far. And Alexandra and I can work on that. I have actually some language about limited permission to practice. So non-lawyers who are granted limited permission to practice that I think might belong in Rule 204, but I was holding back on that in the interest of time. So there might be, maybe we resubmit an updated draft and focus on 208 through 210 and whatever changes Alexandra and I derive from our meeting thus far, and schedule another hour sometime in the next couple of weeks.
I think that makes a lot of sense. I think there have been a lot of really excellent suggestions made. I think this has been incredibly helpful, but I also know it has been long, and so if there are no objections, this may be a good place to stop. But I would encourage you, if you have thoughts on these last 3, go ahead and send them to Lou so he can consider them as he is putting together that other draft. And also, if you have any other thoughts about the things we've discussed, especially any language that could be tweaked, or anything else you want to be considered, please go ahead and reach out to us. Let me open up to the group. Any closing sort of thoughts, preferences moving forward about how we handle things, or issues you want to raise before we leave today? Okay. Professor Verrilli, you gave us a wonderful, wonderful draft with a lot of meat in it, a lot to consider. And we really appreciate all of the hard work that you have put into it. And we appreciate everybody who has stuck through with us through the whole 2 hours and contributed your thoughts and your ideas. The more input we have in this, the stronger it will be. So please continue to think about it, share it, discuss it with others, and provide us feedback. Again, the more feedback we have, the earlier we have that, the better it is, and the better product ACUS ends up with at the end. And that really is our goal. Professor Verrilli, let me give it to you for a couple closing comments.
I will be even less than that. I just want to express my overwhelming and sincere gratitude for the time you all have spent. I feel much better about the draft thanks to your all's expertise and comments. I mean that sincerely. The most nerve-wracking part of this was being the primary steward of it, and now I feel like I'm part of a larger group that that has far more expertise and, frankly, professional gravitas than I. So I'm really grateful for that. Thank you for the time you spent. I look forward to working a little bit more on this. I promise not too much more, to get what I think will be a really good subsection of these model rules.
That sounds great. And thank you for Alexandra for keeping our notes down. Thank you, everyone. Have a wonderful rest of your afternoon. We will be in touch to schedule 1 more hour. And I really hope that all of you will participate and bring all of your excellent thoughts and ideas with you again, because this really has been very, very helpful. All right. Have a great afternoon, everybody.
Thank you again.